Do you have
Indeed.
a guest, Rikki?
Of course I have a guest, Amanda, just for you and all our viewers. And I have a special guest indeed. This is Steve Seeger. He's someone who has been involved as what I call the lawman of the case. Steve, thanks for coming on with me today.
It's a pleasure, Rikki.
You are the law guy. How does that really work?
Everybody on this team has an assignment, and as you say, my assignment is to be the law guy. I handle that well. I mean, everybody, like I said, has a role to play.
Yesterday you had your hands full. Suddenly, the jurors came back with a note. They wanted the closing argument, the rebuttal closing argument of the prosecutor. Now, those of us who have been around, who have tried cases for years, say, oh, they can't get that. It's not evidence. I mean, evidence is witness testimony, exhibits, stipulations. Closing arguments are not evidence. However, this is a strict judge, so you got sent out of the room, and you had to go scurrying about, and what did you find?
Well, we did go scurrying. We took off to Stanford to the office, Jason throwing a 9. We actually had to write out the end part of the brief on the way back up because we don't have any office up here in Norwalk. But what we did find out was there's a statute in Connecticut.
I believe.
We found out that there's only certain things that the jury can take back to the room with them, of course, the information and then the exhibits. And then the second part of the statute talks about what, in the judge's discretion, the jury can hear. And that's mainly readbacks of testimony. That statute was silent on the issue of whether or not closing arguments, which, as you say, are not evidence, whether or not that could be read back. There was some case law as well.
And so you found some case law also from New York. Yes. And it was actually interesting to me when the prosecution still argued so stridently that they wanted that to go in. I mean, I thought that could be reversible error. I want to talk to you as fast as I can about the issue of jury instructions here. I have to say, I mean, I know I'm prone to hyperbole. I mean, I know I'm prone to those superlative words, you know, the worst, the most egregious, just like Marsha Clark would always say in O.J. Simpson. Yesterday, when I heard the judge's re-instructions, in Connecticut, you have something that's called marshaling the facts, that is commenting on the evidence. So when the judge gives an instruction, he can actually go back into the evidence and say, well, witness A or witness B or witness C testified. And I'll say, I mean, I thought he charged you out of the box. How did you feel?
Well, it's a tough call. I mean, marshaling the evidence is the judge's. It's one of the roles that he plays here in Connecticut. As I listened to various examples he gave, you know, it's clear to me that there was an imbalance, I think. It's an imbalance of the instructions. We give several examples of a standard or an element, and then draw from the information the prosecution gave in the case. And then we were thinking that we would get a balanced instruction. He would sort of like pit the scales against us and use one little minor example for our case, and I thought that was a little imbalanced.
A little imbalanced. I think you're being very diplomatic, and I want to thank you for taking some time with us today. We'll see. I know we're all hoping for a verdict today, and I know what verdict you're hoping for. It's called not guilty.
That's correct.
All right.